Welcome back to Court TV. We're now headed to Massachusetts for a pretrial hearing for Kelsey Fitzimmons. The former police officer is accused of assault with a dangerous weapon.
Now this after a fellow officer claims she pulled a gun on him while serving her with a restraining order from her then fiance. Let's go inside that courtroom.
The motion for exculpatory discovery, and that is essentially a Graham McFarland request regarding certifications by the officers whether there's any prior incidents, and that is a predicate to a Rule 17 for that, so that we have a good faith basis, if any, to file a Rule 17 for any further information. And my brother's telling me that that's fully complied with.
Okay.
And I'll defer to him on that.
Okay.
No, I think I complied with my obligations under Rule 14.
Okay.
As far as that first motion, there are things in there that in the first motion that I do not agree to.
Okay.
And we can go through them if we'd like. But other than that, we have a list of questions that we ask every potential witness or police officer.
Right.
Database, but that has all been complied with.
Okay.
But if he wants to talk about the first motion, I'm happy to do that. No action has been taken on it.
Which, when you say first, I've got three motions here.
Motion for exculpatory evidence.
Okay.
Exculpatory discovery.
So that's essentially what we're talking about, Judge, the Graham McFarland request. And, you know, it's also obviously a Brady request as well. So I think it's more than just, you know, Graham McFarland. It's any exculpatory evidence that's known to the Commonwealth, whether it's the Commonwealth prosecution team or the police team as well.
So, Mr. Gubitosi, the motion for exculpatory discovery.
Yes.
What is it that you object to in
I
there?
object to number 1C,
Okay.
number 1D, number 1H, I,
Okay, hold on.
and J.
C, D, H, I, and J.
And then that's on number 1.
Right.
Number 2, he wants me to certify in writing that I have made inquiry of every prosecutor in my office for all items and information critical to the defense. I don't think I have an obligation to do that.
Right.
We did that on every single case. We do have a database. We do have a process. We do ask each individual officer these questions, but we do that on every single case in the county. That's thousands of cases to some 80-some-odd prosecutors every day.
Well, and it doesn't include all of the prosecutors that have passed through the office, that have come and gone over the course of the years. Are you suggesting, Mr. Bradel, that the Commonwealth needs to contact each and every prosecutor that has ever worked in the district attorney's office throughout the officer's tenure?
No, Judge, I'm not.
Well, that's what the motion asks for.
No, it doesn't, Judge. It asks them to have, maybe they could use a computer database. Maybe they can log, just like, you know, lawyers have record-keeping responsibilities. Lawyers have conflict checks. There's all sorts of things that are precedent for this kind of a thing. When a prosecutor has a case where some questionable police activity has arisen, prosecutors can easily document that in this case, Officer Jones was found to be not credible by Judge Smith.
Well, I understand that, but let me start with I. Whether the officer has signed a search warrant, I probably see 2 Frank's hearing requests a month in this session, 2 or 3. Most of them are not allowed. Occasionally they are. And just because there is a Frank's hearing does not mean that there was a finding that anyone gave any false information.
Sure.
So how would anyone determine that?
Well, Judge, again, these are record-keeping requests. And
But who keeps a database of that?
So
For the last 10 years.
when you're a prosecutor in a district attorney's office and you finish a case, you're required to follow office procedures to close out the file.
Right.
And there's no reason why a prosecutor's office ought to exercise willful blindness about these issues.
So you feel that it's up to you to decide how the district attorney's office conducts its business?
It's up to me to decide.
Did you work in the Essex County DA's office?
Judge, I did not work in the Essex County DA's office, but I do know a little bit about it.
What are you speaking about when you say that this is how a DA's office ought to be conducting itself? What's the basis for that?
Judge, okay. I don't think it's a obscure proposition, Your Honor, that when a public agency such as the district attorney's office has to close out a case, that they have to comply with record-keeping obligations under the law, under FOIA, under record-keeping for all sorts of things about what happened with the case.
Well, I understand, but Mr. Gubitosi has represented that he's gone back and searched. They have a process. I'm sure that he'll advise you as to what the process is, and if you want to critique the process, that's up to you. But in terms of them producing evidence that is in their possession, custody, and control, he can only produce what he can search for. And the fact that you disagree, maybe you do, with the way in which they keep records or the type of records that they keep is not an issue that I'm going to decide. I don't know of any case law that says that I'm the one, or you for that matter, to decide how the district attorney's office keeps records. And in fact, I'm not going to order anybody to retroactively go back and search records from, I don't know how long the officers who are witnesses in this case have been police officers in this county, but do you know, Mr. Gubitosi, off the top of your head?
I know one of them is 20-something years.
Yeah, so I'm not sure that I can.
Let's do this. Let's bring in our guest for the hour, criminal defense attorney, former prosecutor Lindsay Richards. Lindsay, thank you so much for being on with both of us. I got ahead of myself because I wanted to say to you, boy, the allegations that continue to face law enforcement in the state of Massachusetts, right? We have yet another incident where she allegedly pulls the gun on her ex-fiance. Now, the defense attorney said he's not credible. Right? He's not credible. I guess that means that she may try to allege it didn't happen. But tell us your thoughts as you hear this unfold.
Well, I have a lot of thoughts just about the initial arguments that are being made requesting exculpatory evidence. I think what this particular defense attorney is trying to get at is that he is wanting any, disciplinary history, misconduct by any of these police officers, any internal investigations that might have taken place with them. And I think he's really trying to figure out if there's any type of conspiring between the district attorney's office and these officers, or any kind of misconduct that might be taking place. And by the way that this case has been handled, from what I've seen so far, it doesn't seem like that's a huge stretch to think that there's something kind of nefarious going on, because they denied her bail based on a request to change her alcohol monitoring. So they requested that they change her alcohol monitor because she was having difficulty with it, and then they just revoked her bail and are keeping her in custody and denying her any new bond. And that's really shocking to me, to be honest.
Well, Lindsay, I want to bring it out a little big picture here. Speaking of shocking things, I was just telling Ashley here when we were watching, as I was getting read in on this case, the North Andover Police Department in 2025 does not use body cameras. That just blew my mind. I was just under the assumption that all police departments used body cameras. But because they don't use them, there's obviously a lack of recorded video evidence of what actually went down. How does that lack of visual evidence shape the defense's strategy here and, the prosecution's burden in this case?
First of all, that is mind-boggling. I cannot believe in 2025 any police department does not have body-worn camera. And if they did, right, there wouldn't be nearly the questions that we're having right now about the integrity of these police officers, because we would have video documentation of what happened. But because there isn't, it gives the defense, as it should, a complete, playground essentially to make any argument they want about how this actually went down and, potentially misconduct by these police officers, because it's just the officer's word against hers about what happened. That is shocking.
And, you know, Cody and I were just talking about it briefly, and the fact that I'm aware of some counties that don't do it, citing the financial responsibility of getting those and getting them working. But I would agree that that's not a good reason to not have them. I don't know why they don't have them there,
Right.
but it happens sometimes. It's just not a good reason.
It's going to be interesting to see how this all plays out and how they try to, you know, construct their competing narratives when this finally goes to trial.
Yes.
But coming up, we're going to stay in Massachusetts for the pretrial hearing of former police officer Kelsey Fitzsimmons. Stick around. Welcome back to Court TV Live. I'm Cody Thomas here alongside none other than Judge Ashley Wilcox.
Nice to be on with you, Cody. We are still in Massachusetts for a pretrial hearing for Kelsey Fitzsimmons. This is the former police officer accused of assault with a dangerous weapon.
Now, this comes after a fellow officer claims she pulled a gun on him while serving her with a restraining order from her then fiance. Let's get you back into that courtroom for more.
They don't have, but there is a, whether the officer has ever attended or presented at a law enforcement training by the private vendor.
Judge, before we jump off of that one,
Yeah.
all the Commonwealth has to do is ask the officers. There was 4 officers that were at the scene. Right. They can ask 4 officers, were you ever involved in a Franks hearing? There are ways to do this. We don't have to act like this is some obscure thing, Your Honor. This is exculpatory evidence. We have every right to all these things under Graham McFarland and under Brady.
What case says you have a right to find out whether any police officer on any case has ever refused to answer questions?
A police officer in our case, Your Honor.
No. In this case, what is the precedent? You've got to cite, where is the case or statute that says that a police department has to disclose to you or to anyone else when an officer declines to answer questions? There are a lot of reasons for that, I can assure you. And I'm not aware of any records that are kept of that. And I can assure you that it would never be admissible under any circumstances. So I'm having a hard time with the concept that the DA's office or the police department has to supply you with the fact that an officer 15 years ago declined to answer questions after a shooting at the scene, but 2 days later answered the questions, for example. Happens quite frequently. So I am reluctant to say, I doubt there's any police agency that keeps records like that. I don't know of any, but certainly the district attorney's office doesn't keep records like that.
Your Honor, I certainly am not telling you anything you don't know, but just put it out there on the record. When an officer takes the fifth, so to speak, it's been found that a truthful answer would incriminate them. So it's incriminating information.
Who's made that finding? That's an interesting concept, because I probably represented thousands of officers at interviews, and I yet to have or even hear of someone making a determination that that person had a Fifth Amendment privilege or not. My experience has been that the department offers people a rights form, and if the department has made or ascertained that the person has a self-incrimination right, far be it from a lawyer to question that when the prosecuting or investigating agency is doing that. So again,
it's built into the law of the Fifth Amendment, Your Honor, that you can only take the Fifth Amendment when a truthful answer will incriminate you.
That's assuming you're ordered to, and that's assuming that the order also encompasses the nuances presented by the state constitution, which requires transactional immunity to overcome it under Carney versus Springfield. So it's not as simple as you make it sound. But let's get back to the fundamental issue. Does the district attorney's office keep records of any officers that have ever invoked their rights at any proceeding that the district attorney's office is aware of?
No.
Okay. And if, with regard to the police department, Mr. Bradel, I'm not aware of whether they keep records of that or not. But I am certainly familiar with the fact that even if that were true of a particular officer, it certainly is not admissible.
Judge Grant McFarland has a whole host of things that are not admissible, or an optimistic defense counsel might say not yet admissible, but that's not a exclusionary factor, Your Honor. So you can't really go there. And these are all, we don't need to pretend like the officers are in Alaska. They're down the street.
No, I understand.
The Commonwealth can ask them all these things.
But does that case say that all records pertaining to an officer, any officer who has ever invoked his or her rights, either under the Fifth Amendment or Article 12, records have to be kept and they have to be disclosed? Does the case address that?
It does not say anything about
Does the case address whether or not an officer who is the subject of a pending internal affairs investigation unrelated to the matter that is before the court, that those records need to be produced?
Yes.
Okay. And what about whether the officer has ever testified in a motion to suppress, which the motion was allowed because the officer violated? It's pretty broad in terms of violating the defendant's rights, but assuming we could refine it a little bit,
Sure.
Does the case say that you must produce that? And who's charged with keeping those records?
Your Honor, Brady says we have to produce that. The Constitution says we have to produce
On any motion to suppress that was ever allowed?
If an officer is found to be not credible,
Well, see, we're talking.
Well, hold on. Those are two different things here. The fact that a motion to suppress is allowed does not necessarily mean that an officer was found to have lied or made false statements. There are two different things. People make mistakes. The purpose of the exclusionary rule is to deter police conduct, but not every motion to suppress is allowed because a judge finds that an officer lied. Yes, the motions are allowed because in the court's judgment, for example, a stop was unjustified, but that doesn't mean that the court found that an officer lied.
that's
In fact,
not
I'd
what
say
we're
most
talking
of the time that's not the case.
We're not talking about a legal ruling about an officer's conduct. We're talking about when an officer's been found not credible, and that's what we're looking for, Judge.
Well, does your office keep records of decisions by judges saying that officers made false statements or are not credible?
Yes.
Okay.
And so, and he's being cute because what he's writing in this motion is much different than what he's saying here.
Did you check the database for what I just outlined?
Yes, and we asked these officers, and he knows this, we asked these officers a whole host of questions about whether they have any convictions or convictions for certain facts about criminal offenses. And I'll just adverse credibility findings against them from any court. Pending criminal investigations into your conduct. Findings that you have engaged in bias, racial, or profiling, discrimination of any kind. Findings that you have engaged in untruthfulness or other misconduct implicating credibility.
And have those questions been asked of the witnesses in this case?
Yes.
And have you provided any information that's responsive to those questions?
Yes,
So what's the complaint, Mr. Bradel?
Well, that's what I'm asking, is if it's complied with. And
You just said it was.
saying it was, and counsel got up and seemed to be wanting to correct me on that, and so here we are.
Okay.
So is it complied with or
Well,
not?
it's on the record. What else do you want?
The motion speaks for itself, Your Honor. I just want to know what the Commonwealth is objecting to.
Well,
They gave us a list, and we can go through it.
the list of questions that you asked?
Counsel objected to 2C. Have they ever refused to answer questions citing their constitutional rights? We had a little bit of a debate about that. I think that's, Judge, a firing offense. I believe that assistant attorneys general have been fired for that. I believe officers have been fired for taking the fifth.
Really?
I think it's exculpatory.
In the absence of transactional immunity, officers have been fired?
I think it's
You should read
exculpatory.
Carney versus Springfield, and I think you'll find that you're incorrect.
Well, Judge, I think that an officer that takes the fifth in this case about something else is saying, if I answer that question, a truthful answer will incriminate me. So I think under Graham McFarland, I think that's certainly
The case doesn't say
exculpatory
it.
and discoverable.
The case doesn't say it. I don't agree with you. Carney versus Springfield says otherwise, okay? And I don't agree. So, Mr. Gubitosi, have you provided a list of the questions that you have asked to the officer, or can you, or will you provide the list of questions that you ask?
Cody, it is nice to see a judge that's paying attention. Pretty feisty up there.
It's getting a little hot in there.
It is getting hot in there, but he is challenging the attorney to make sure he gets all of the arguments on the record. Wow.
As you mentioned, they're trying to throw some at it and see what sticks as he's trying to throw anything at the judge. And the judge is like,
Not having
Yeah.
it. All right, we're going to stay in Massachusetts for the pretrial hearing of the former police officer Kelsey Fitzsimmons. We'll be right back after this short break.
The disappearance of mother Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walsh was suspecting his wife of having an affair.
The massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind.
He searched how long before a body starts to smell.
The disappearance of Anna Walsh murder trial. Live coverage begins December 1st on Court TV.
Welcome back to Court TV Live. We are still in Massachusetts for a pretrial hearing for Kelsey Fitzsimmons. The former police officer is accused of assault with a dangerous weapon.
This comes after a fellow officer claimed that she pulled a gun on him while he was serving her with a restraining order from her then fiance. We want to get you back inside the courtroom for more.
The answer to all of those questions is no, and they've asked them. I'm not seeing anything that would indicate otherwise in this case. Then you need to examine the questions, and if you feel there's something that wasn't covered, then you can refine your motion. But I am not going to allow, and I don't think I agree with your view of the law, that whether or not an officer is refused to answer questions, citing constitutional rights is something that you're entitled to. In the immediate aftermath of critical incidents, officers often advantage themselves of the fact that the police department does not have transactional immunity so that they can have an opportunity to speak, sometimes within 24 or 48 hours. Happens all the time. And in fact, officers are often interviewed thoroughly thereafter. So the case does not say that if you refuse to answer questions, it is fireable. In fact, it says quite the contrary. The police department does not have the ability to grant transactional immunity. Only the Commonwealth of Massachusetts, the district attorney's office, or the attorney generals have that ability. So to suggest that a chief of police or commissioner could fire someone for invoking their rights without giving them transactional immunity is incorrect. And so, as to the extent you're asking for that, it's denied. Now,
the next one is D.
Yeah.
Whether the officer is subject of a pending internal affairs investigation or any internal affairs investigations into the officer's conduct, whether these have resulted in sustained findings of misconduct. I'm not sure why there's an objection there.
Well, the way it reads is different than the way he says it.
Okay.
If there is a sustained finding, absolutely.
Sure.
And there hasn't been in this case.
Okay.
With any of the officers that are involved.
Okay. So that's the answer to that. And as far as the other questions, it seems to me H and I are covered by the questionnaire, but J.
Well, no, H, if I might just say, H and I, if you're going to deny them, but they're different than what he's saying.
No. I is only, you only need to respond to I if there's been a finding by a judge that there was a misstatement in the search warrant affidavit. Not whether or not defense counsel has filed a...
All right, let's take an opportunity to bring in our guests, attorneys Lindsay Richards and now joining us, Krista Ramey. Thank you, ladies, for standing by. Krista, let me ask you this. I just want to point out that the defense attorney is Timothy Bradel. He also represented Turtle Boy. Turtle Boy involved, as you know, familiar with the allegations of ex-law enforcement, Proctor in the Karen Reed case. A lot of different officers accused of pretty egregious things in terms of their job responsibilities, biases, etc. Do you think any of this is playing in, Krista, to the defense's arguments?
Well,
I mean, I think that, some of these arguments are, pushing the envelope a little bit in terms of, what the immunity arguments that and exercising a Fifth Amendment right arguments were kind of interesting that were being made there. And I like that the judge is challenging this attorney. I think this attorney I think it's his style maybe to press the envelope a little bit and to push these arguments. But by the way, I think that it's just a good strategy because you do want to press the outside of some of these arguments when you're representing someone. You don't want to just stay within the lines because sometimes that is not going to be, fully representing your client in the most, zealous way possible. So I think that he's doing a great job. I like the challenging of this judge, though. I think that this judge is fantastic.
Mm-hmm.
And Lindsay, I want to touch on the prosecution here. When Fitzsimmons was initially brought in, they initially pursued this intent to murder charge, but the grand jury ultimately rejected that. So to me, the question I have is, does that rejection weaken the prosecution's overall case, or is it more of an idea of it's narrowing the focus on a more provable case?
I think that's right. I think the latter part of what you said is correct. I think most likely they kind of brought before the grand jury a more serious charge, and the grand jury ultimately said, it sounds like the evidence you have is going to be able to prove this particular charge and not necessarily an intent to kill. It also sounds to me, quite honestly, like this district attorney's office, and having been a prosecutor myself, is maybe a little behind the times in the way that they are documenting their officer-involved misconduct and allegations of misconduct. Most DA's offices at this point in 2025 keep a thorough documentation of, any allegations of untruth, any internal investigations, and that is always disclosed in every single case. And it kind of sounds to me, and again, I don't know all their policies, but it kind of sounds like maybe they're behind a little bit in the way that they're documenting.
And speaking of that, in the last 30 seconds, Krista, we'd like you to weigh in on something we've all discussed, no body cam videos for these officers.
I heard y'all talk about that earlier. I was floored on that because it does, I think your other guest is correct. This allows, some arguments to be made that might not otherwise be made. The allegation is that she pointed the gun first. How do we know that? We don't have any evidence of that. And now it's a he said, she said case. And I think that really weakens the prosecution case and really helps the defense in this case.
Yeah, it's pretty unbelievable, but viewers are weighing in and saying there are other jurisdictions.
And I'm just glad to know that I wasn't the only one that was shocked.
All right, you're right, absolutely.